Today we are here to discuss the rights of residential renters in the District of Columbia. The purpose of Renters' Rights 101 is to provide renters with a brief overview of their rights and responsibilities. Now let me ask, how many of you in this room consider yourselves to be first-time renters? I hope you learn a lot. In fact, I've got to make sure they'll kill me if I don't use this microphone stand in front of it. I hope that everyone in here will learn a lot, because even though I did say this was going to be a brief overview, I can assure you there's a lot of stuff in here, and you may want to take your handouts home and read up on some of these things. But I'll say that you're getting in on the ground floor. And if this thing Windows is not genuine, this is the first of a series of Office of Tenant Advocate presentations and publications. There's a whole series of topics we're going to talk about today. There will not be a test at the end. You do not need to memorize these. But over the course of the next year, there should be a standalone presentation for each and every one of these subjects. But you get to hear everything first by being here today. The purpose of this presentation, well, let's skip that. I told you that. I have to say that please do not hesitate to contact the Office of Tenant Advocate. If you have any dispute with your landlord, you have any questions about your tenant rights or your tenant responsibilities. Yes, remember, everyone has rights, even the landlord. Everyone has responsibilities, even you guys. But speaking of questions, I suspect that some of the rights presented here will lead to some questions about those rights. If you are one who has such a question, please write it down on that 3x5 note card that you found on the table in front of you when you came in. It will be collected by Mr. Mokhtari right here. And no matter how much information we wind up presenting to you, I promise you we are going to save some time at the end to answer as many of these questions as we can. It is possible that there will be sufficient questions that we do not have time. So I would encourage you to put a name and contact information on the card with your question. We will be contacting every person who has an unanswered question this coming week, as long as we have that contact information from you. Now, just a few words about today's presentation. Normally, a presentation of this scope would be presented by one of OTA's litigating attorney advisors. However, you're in for a special treat today, because today you will hear from not one of OTA's attorney advisors, not two of OTA's attorney advisors, but you will hear from all four of OTA's attorney advisors and get to know them. And so that you have more chance to listen to your rights. Oh, I better tell you, here's who they are. I'll announce them again before they speak. Do not worry. So that takes us back to this thing, which will probably blind you with all the redness. Enjoy. But I know that you would rather hear from these attorney advisors more than you would like to hear me speak about these preliminary matters. So I'll just tell you, my name is Dennis Taylor. I am the general counsel of this agency, and I have the pleasure of working with these 4 people every day. And the first one of them that you are going to hear from today is Miss Ramona Quillette, who's either going to stand here behind this podium or take this handheld microphone. And you notice she just walked in, so we haven't had a chance to discuss which. It'll be a surprise to me just as much as it is to you, and frankly, maybe to her as well. So I give you Ramona Quillette.
Hello, everyone. So, I'm a little bit out of breath, but I'm so happy to be here with all of you. As Dennis said, my name is Ramona Quillette, and I'm one of the attorney advisors here at OTA. And so what I'm really going to be talking to you about is sort of the pre-renting phase of being a tenant. So when you're first identifying your apartment, when you're filling out the application, and what sort of disclosures that you can expect to receive from your landlord. So just by show of hands, is there anybody out here who's currently looking for an apartment? Oh, great. So let's start with what sort of things are you thinking about when you're looking for an apartment? What sort of criteria are you using to pick which places to even knock on the door and see if they're renting? All the way in the back?
What about my income?
Absolutely. So budget is one of the most critical criteria when you're looking for an apartment. And here's why. The majority of people who are being evicted, it's for non-payment of rent. And the majority of people who can't pay their rent, it's because they cannot afford their apartment anymore. And so when you're looking at a unit, you should be very, very conscious of how much you can spend and how much you can afford to spend each month. And keep in mind that if you're looking for a long-term rental, the rent will increase every year. That's pretty much a given. If it doesn't increase on you for some reason, you thank your stars and you say, hallelujah. But in most cases, your rent's going to increase, so keep that in mind when you're choosing an apartment. Now, I know I saw another hand. Are there any other criteria that we're looking for when choosing an apartment? Yes, ma'am.
I'm looking for senior housing for independent living.
Yes. So that when you have a very specific consideration like that, much like when you're looking at prices, if you want something that's more affordable or on the lower end as far as price is concerned, you're going to have to be very flexible about your location. And so senior living is difficult to find, but it is not impossible. And there are apartments at every price point here in the district. So other things you might be looking at when you're trying to decide where to rent, what sort of amenities are provided as part of your rent. So is there going to be a washer dryer inside your apartment? Is there going to be one in the building? Are you just going to have to go to a laundromat? That sort of thing. And so when you're trying to find an apartment, what we would recommend is to carefully search using all available resources. So there's online, obviously, it's really one of the primary ways people find apartments these days. But there's also newspapers, such as the Ready to Rent section that's in the Post. You also have word of mouth, which is underutilized, but very, very important. So you know somebody whose cousin is moving out of the district, they're relocating for work, and all of a sudden their unit's for rent. Or someone who owns and wasn't planning on renting out to a tenant, but all of a sudden they need someone to rent their unit. Hold on for me. I'm aware. Thank you, Dennis. Now, I want you guys, yes ma'am.
I wasn't in here when you first started, but little or no information is available about housing in buildings that are being built up and new buildings that are coming. But I understand there's legislation that says every building that's being built partner-wise has to have some limited amount for low to moderate income. That's not talked about. And when you ask the real estate people, they claim not to know. I was told that the only way you can get it is take the legislation to them and let them know. Now you have such and such and such for this and that. I want one of them.
All right, ma'am.
Usually you get it.
So, hold on one second. the lady in the front wanted everyone to know that in the district, there are certain requirements for new buildings that would have, excuse me, ma'am, that would have set aside a certain portion of the rent, or of the units available to rent for low and moderate housing, or low and moderate income housing. Now, the specifics of that legislation are a little bit complex, and they're outside the scope of this presentation. But if you'd like more information on that, I would encourage you to come down to OTA, make an appointment, and we'd be more than happy to flesh that out with you. Okay, so actually, if everyone could hold their questions till the end, I just want to make sure that I give my colleagues ample time to go over their portions. So I'd rather us not get bogged down in just the before you even rent your apartment section. So we've talked about how you identify a unit, and I'm going to introduce you to one of my good friends. It is Mr. Red Flag Man. And you will note every time in our presentation there's a specific issue that we want you to be aware of, something we want you to pay attention to. You'll see little red flag man down at the bottom waving his red flag. So when you're identifying a unit, these are some of the issues that we've noted as they should raise a red flag for you. They should give you pause before you apply or before you even give anyone money, specifically before you give anyone money. So do not rent any apartments sight unseen. Just don't do it. It's a bad practice, and it's something that unscrupulous people use to take advantage of tenants. They know that you want an apartment, they know that the housing market's tight, so they do these things to try and take advantage of you. Other big ones that I want you to be aware of is if a deal sounds too good to be true, it is. If anyone's renting you a $300 a month apartment in Georgetown, that's 3 bedrooms, that's not a valid listing. That's just not going to be legitimate. And so the other big one that I want you to take away from this slide is do not rent apartments that don't exist. And that sounds silly, but it's really easy to do. Someone says, oh, I've got an apartment at this address, and they put it in Craigslist. And you say, oh, that sounds nice, and it sounds reasonable for that neighborhood. But what you should do is, at the very least, just go to Google Maps, put in the address, make sure that it is a valid address and that the place actually exists that you want to rent. Moving on, verifying your unit. Now, for this slide, I want you all to know that there are 3 things that every housing provider who is in compliance with the district laws and is on the up and up is going to have. These 3 things are, first, a basic business license. Now that license says that I'm a housing provider and I'm licensed to offer this rental housing to you, whether it's an apartment or if they're renting their single family home, or condo. Number 2, oh, I got all 3 up now for you. Number 2 is going to be your certificate of occupancy. Now this one's more of a technical requirement. It's basically saying that this housing accommodation is zoned or is allowed in this particular zone. So it's not something that most people are aware of or something that is an issue for most people, but please be aware that a housing provider who's, except for single family housing, is required to have a certificate of occupancy. And then the number 3 is the housing provider should be registered with the Department of Housing and Community Development. Now this registration will tell you whether that apartment is under rent control, which is an idea that we're going to talk about in more detail later on in the presentation, or if the housing provider is exempt from rent control, which means that there's other factors that control how much they can increase the rent each year. And so, the second appearance of our red flag man, he's just letting you know that these 3 things should be disclosed to every single rental applicant. So, at every apartment that you look at, every apartment you apply to, there should be 3 things that are disclosed to you. Can anyone tell me what those 3 things are?
That should be what?
3 things that are disclosed to you if you're applying to rental housing in the district. I'll give you a hint, they're on my slide. No one wants to volunteer?
Business license, COO, and registration.
Thank you, ma'am.
You're welcome.
All right, so this slide is so important, I want you all to read it with me. So, a housing provider's Failure to be properly licensed or registered generally does not render a lease null, void, or unenforceable. The lease will likely remain binding on all parties. So, what that sign is saying, what that slide is saying, is that if your housing provider does not have a basic business license, if your housing provider does not have a certificate of occupancy, or if your housing provider is not registered, that does not relieve you from your obligation to pay rent. So just be aware that if you thought, aha, my housing provider is not licensed, I've got him now, I will stop paying rent, that's not exactly how that works.
That gets people in trouble.
Exactly. You can report your housing provider to the Department of Consumer and Regulatory Affairs if they're not properly licensed, and you can file a document challenging their registration if they're not registered. But you still have to pay rent. So, one more time. If your housing provider is not licensed, does not have a certificate of occupancy, and is not properly registered, you still have to pay rent. All right. Yes.
Put it in escrow. If there's something wrong with the apartment and they haven't repaired it, they told me I have the right to put it in escrow until they do it. The rent.
I understand what you're saying, and if you hold on just 1 second, we'll talk about the housing code and what sort of requirements the landlord has under the housing code. And so, I say and so all the time. As far as applications, you found the apartment that you want to rent, you think it's absolutely fabulous, and now it's time to apply. They're going to ask you for a lot of information. They're going to ask you for a lot of personal information. So they can say, oh, they'll run a credit check, they'll run a criminal background check, they might ask for references from your previous landlords, and all of this information. And if you don't feel comfortable giving this information, it may be difficult for you to find an apartment. I just want to be upfront with you about that. There are some limits to the credit and background check, but those are set by federal law, and we can go into more detail with that if you think your landlord's crossed the line, if you'd like to come into our office and ask for assistance. Red flag man's back because there are some common things when it comes to applying for an apartment. One is a co-signing provision. Just so everyone's clear about what a co-signer is. If for some reason your landlord feels that you may not come through with paying rent every month in full and on time, then your landlord may require you to have a co-signer. A co-signer is someone who is responsible for the rent if you don't pay. Now, some landlords like co-signers, others don't. And either one is permissible under the law unless you think a landlord is not allowing a co-signer for a discriminatory purpose. And I keep saying this, but we will go over discrimination in the District of Columbia in a couple slides. Holding fees. Now, holding fees are those handy-dandy fees where you find your apartment, you apply for the apartment, and the landlord says, well, if you want us to take this off the market and not try to rent it to someone else, then you give me this holding fee. Beware of holding fees that are too high. Now, too high means that if you, for some reason, you do not rent the apartment, worst case scenario, and your landlord keeps the holding fee, and you have to sue your landlord to recover that holding fee, that you are then kept from finding a new apartment, or you're somehow financially harmed. If their holding fee is too high, do not pay it, look for another apartment. Now, when it comes to holding fees, things that you absolutely must have, if you pay a holding fee, you absolutely must have a written receipt. There's no two ways about it, because the worst thing is when you come to us and you say, I gave them $200 to hold my apartment, and now they won't give it back. And we say, all right, do you have a receipt? Do you have any documentation asking you for this holding fee? And you're like, no, they just said, give me the money, and what do I do now? Now they won't give it back. Well, there's really not a whole lot we can do, because we don't have the proof that you paid it. And this second part, you want to make sure your holding fee is refundable. And to know if your holding fee is refundable, it's not enough to have them just tell you that they'll give it back if you don't rent the apartment. You need it in writing, because that gives you the strongest case ever when you want to, if you don't rent the apartment and you need the money back, that they owe you the money. You say, I have a receipt for the holding fee that I paid, and I have a document where you say it's refundable. And then last point on applying for your unit is generally when you're looking at apartments, people want to give you a tour of a really nice unit. You need to find out if that is the unit you will be renting or if that is a model unit. If it is a model unit, please, please, please ask them to be very clear about how that is different from your unit. Maybe the model unit has granite countertops and the ones inside your units are going to be laminate. Maybe it's that the model unit has like a nice little den, but your unit won't have a den. Whatever the differences are, you want to know those up front. And, oh,
May I ask a question about the fees for background checks?
so,
It's a specific question. How should a landlord handle, let's say the landlord has several applicants who all show up at the same time, and there's a non-refundable application fee. Is the landlord responsible for doing some sort of priority so that they don't accept fees from everybody, knowing that they can't get back, or how is that viewed by the law?
So that is a very specific question, and the law, unfortunately, at this time doesn't specify how that's supposed to happen when you have multiple tenants applying for one unit and there's a non-refundable application fee for the unit. I'm not sure how that would be addressed in your particular circumstance, but if you wanted to come by and talk to us, we'd be more than happy to talk with you about what you can expect, and if you were trying to file some sort of complaint against the landlord for that purpose. Moving swiftly on, disclosures. So, disclosures are sort of split into a couple of different moving parts. The first one is, what disclosures can you expect as an applicant for rental housing? Like, you've just put in the application. You're not even officially a tenant yet. You haven't signed a lease. And then they're further split in what sort of disclosures is your housing provider required to give you based on whether the property is under rent control or not. If rent control applies, the landlord must disclose to a rental applicant basically things that will affect the rent or could affect the rent. And that's going to include housing provider petitions. It's going to include any sort of housing code violation report issued by DCRA in the last 12 months, or any housing code violations that have been issued by DCRA that still haven't been fixed. And then lastly, there's a pamphlet that you're supposed to get that's published by the government that explains how rent increases work under rent control. Now, if you're a new or existing tenant in any sort of property, rent control or non-rent control, then you're supposed to get certain portions of the housing regulations. Now, these portions of the housing regulations are going to be basically your housing code, and it's going to tell you about security deposits and how your landlord should handle security deposits, and also notices of violation and how the government enforces those notices of violation. And then if you're in a rent control unit, whether you are a new tenant or an existing tenant, you have the right to get the history of rent increases for the past 3 years on your unit. This history of rent increases will tell you what the rent increase was and also what the basis was for the rent increase, whether it was the annual adjustment or if a vacancy increase was taken on your unit or whatever the case may be. Now, here's my last slide. Don't get too excited. My last slide is about lead disclosures. Now, I have my lead disclosures over there, so I'll go grab them for you so I can show you what they look like. All right. If you rent rental property in the district, then you are entitled by law to get disclosures of whether there is lead in your unit or whether your landlord has a basis to believe lead's in your unit. In addition to that disclosure, you get these pamphlets that are required by law. The first one is from the district, and it's tenants' rights under the district lead law. It looks like this. And then the other one is this much longer pamphlet that's called Protect Your Family from Lead in Your Home, and it's put out by the federal government. If you have any questions about these pamphlets or if you'd like a copy of these pamphlets, please contact our office, and you can contact our lead specialist, Mr. Aaron Poquet. And that's it for me. I've had a lovely time with all of you, and we'll be available for questions and answers at the end.
Thank you, Ramona. Now it's my pleasure to introduce to you Mr. Aaron Polkay.
Good afternoon, everybody. I like to walk around a little bit, so I'm going to use this. Am I on? All right. I am here to discuss this afternoon the lease. How many people know what a lease is? Raise your hand if you know what a lease is. Obviously. How many people here are under an oral lease? You didn't sign anything. You just agreed orally to rent property. Nobody. I'm about to tell you. How many people here are under a written lease? Just like one of these, a written lease. Well, in the District of Columbia, both oral and written leases can be enforced. But we don't like for you to have an oral lease, obviously. Because if you do have an oral lease, that means that you have to prove that you have a relationship with your landlord. The people who come into our office and they pay rent in cash, they don't have any receipts, they don't have any documentation, they don't have any utility bills in their name, we can still work hard to prove that they're tenants because oral leases can be enforced. But that makes it very difficult for us. So the first thing that we ask everybody, and we encourage you all to have, is a written lease. And if you come to our office and you talk about whatever your issue is, you'll find that the first question I'll probably ask you is, what is it? Where is your lease? So when you come visit us, here, which way? We have people who we're webcasting this, so we want to make sure that we're catching everything. So the lease establishes the rules of the game with your landlord, and that's why we look to it first. As I just explained, a written lease is not required, but regulations do say that if you are under a written lease, your landlord has to give you a copy of it. There are tenants out there who've signed a written lease but never had a copy of it. If that's a problem that you face, come see us, and we'll help you communicate to your landlord why you should have a copy of your written lease. Another thing that's important to know is that your landlord just can't change your lease without asking you for permission first. So if you somehow mysteriously get a copy of your lease at a later date that says different terms than what you remember signing and you don't remember ever agreeing to, that's a problem. That's something for us to talk to you about. They cannot unilaterally change the terms of your lease. And here's another very important part about your lease. How many of you have heard about this notion of the month-to-month tenancy in D.C.? Yeah. I mean, month-to-month tenant. Now, raise your hand if you think that that means that with a month's notice, your landlord can kick you out. All right, well, I'm glad not very many of you raised your hand because that's not true. In the District of Columbia, your landlord cannot end your lease just because the term is up. If you signed a year-long lease and the year is up and you live in D.C., your landlord can't say, your year is up and you have to go. No, you automatically become a month-to-month tenant if you want to stay. And then even after that, your landlord can't say, your month is up, you have to go. As long as you pay your rent and follow the rules of your lease, you can remain a tenant forever under a month-to-month lease. Now, there are certain other things a landlord can do to ask you to leave. For example, if the landlord sells the accommodation and the person who buys it's moving in themselves, or if the landlord puts certain filings in and says, I'm moving in myself, those are ways that they can get you out. But the mere fact that your landlord wants you to go because the time is up, or they don't like you, or y'all got into a fight, if your landlord gives you any notice like that, you need to come see us, because all day long we write letters to landlord that say, no, no, no. They're going to stay. And there's nothing you can do about it. And I dare you to take them to court, because the judge will laugh them out of the courtroom under those circumstances. Now, if you sign something, and again, if you have any questions, we encourage you to see Hisham. You can write your question down. But as you can see, I'm trying to get through this so we can get it all done. And you can come and talk to me afterwards. I'll be in the lobby and I'll answer all your questions just for you. I see you shaking your head. I got you. Now, if you sign something, what do you have to do? Read it. Don't ever sign anything you haven't read or understand. Very good point. A lease is a legally binding contract that sets up rights and responsibilities. And if you just flip to the last page and sign it, but you've signed away something, or you've agreed to something that can be enforced against you, well, you might be bound by that, even if you come and say to me, I didn't understand it. Well, what am I supposed to do? No, you got to read your lease. You have to read your lease before you sign it. Because if you do read it, you may see some catchy legal phrases like joint and several liability. What does that mean? Well, that means if two people sign one lease, they're both basically the same person. If one person breaches, the other person's in breach too. That's very important for roommate leases. How much do I have to pay to move into this place? Your landlord comes after you 6 months down the road and says, you didn't pay your security deposit. Well, did you know what the rules and regulations were, what fees you might have had? What if you lived there for a year and you've already agreed that after the first year your rent's going to go up because you got a discount the first time, but you didn't see that in the lease when you signed it? Paying the rent on time. What if you thought that paying by the 5th makes you on time just because you didn't have a late fee, but you were still late because you paid by the 5th? So they can evict you for habitual tardiness, although they never charge you for a late fee. You signed that away when you signed the lease you didn't read. What are the penalties for late payment? 50%, 10%, 25% of monthly late of your rent. Something ridiculous like that. You may have signed that away. Is water included? Is the electricity included? What about cable? What about yard maintenance? Your lease actually has to say whether or not you're responsible for cutting the grass, but you might not have known that you signed that responsibility. Your grass is up high. Landlord says that's your fault. You say, why? Well, you signed the lease and it said that in it. Subletting limitations. Your landlord says you can't sublet this no matter who, what. You will never ever be able to sublet under this lease. I can even give you improper or discriminatory reasons limiting your subletting rights. Well, it's very important for you to be aware of that. And then how do you let your landlord know that you're ready to move out? How much time does it take for you to let your landlord? Is it 30 days? Is it 60 days? Is your landlord being tricky with the law? In that respect, you have to be aware of that in advance. Now, the next two slides, we're going to do some word art here. This slide is things to be aware of. So these things are in leases, and they're not necessarily illegal, but you might want to raise your eyebrow and read these provisions carefully. I just talked about the grace period. This is that circumstance where you don't get a late fee to the 5th of the month, but your rent's due on the 1st of the month. So if you paid your rent on the 4th of the month all year long and never had the late fee, you were late because that's what the lease says. You have to be careful and read those terms very carefully. Is there a house manager? Some landlords demand, in the case of student housing, that there's only one person responsible for the entire lease. Well, that house manager isn't any more responsible than the person who didn't pay attention to anything. So you have to be careful and see what decisions your house manager might be making that impact you because of that notion of joint and several liability. And then in some student circumstances too, landlords might say, hey, you got to find your next tenant, my next tenant, and then you just have them pay you the security deposit. Don't worry about dealing with me. Well, everything I did to tear the place up, when you paid me the security deposit, I'm gone with the money. But you're liable to that. Only and always pay your security deposits directly to the landlord. Your security deposit is a relationship between you and the landlord. If the landlord's trying to skirt that responsibility off on you, that's something to be aware of. You're dealing with the landlord who's acting trickily or being tricky. Now, these are things to be aware of. These are things that when you see these things on the lease, you might not want to sign this lease. Blank spaces. What happens with a blank space after you sign? They fill it in. That's what happens with a blank space after you sign. You should know that. Missing landlord contact information. Landlord only wants to give you a P.O. box. What if you want to sue the landlord and I have to get a process server to find that person? We're going to stand in front of the P.O. box all day long to see when he shows up? No. You need your landlord's street address, phone number, any contact information you have so they can be fined in case you need to sue them. Again, I already spoke about excessively high fees. I mean, if your late fee is $100 just because you were late, you don't want to rent there because you might be late one month. You're paying $1,000 a month in rent. You mean to tell me your late fee is $100? You're dealing with somebody who's trying to rip you off. Lease addendums. So at the end of the lease, they'll have this thing that says house rules. If you don't wash your dishes or if you leave something out in front of the house, then you're in breach of the lease because this addendum is part of the lease. The things that you sign at the end or see at the end that are addendums may establish additional rules that will bind you. You have to read those things carefully. Complex arrangements for the payment of utilities. The landlord says, I'm going to give you the water bill, and this building has 8 units, so I'm going to give you the water bill, and you're responsible for 1/8 of the water that month. I'm going to give you the water bill whenever I feel like giving you the water bill. I'm going to have you trust that that's actually the right water bill, and then if you don't pay your 1/8, then I'm going to put you out. Nah. You don't need to be dealing with landlords like that. Either you're going to have the water included, or you're going to need to be able to get a direct line to pay for the water yourself or whatever other utilities are. And these are some other things that come out. Some landlords say you got to remove stuff that you found in there. No, you take the previous tenant stuff out. We already talked about subletting. Some landlords have said, I can kick you out for immoral conduct. Well, what's moral to one person might be immoral to the other. How are you going to be able to say that you can kick me out for that? You're dealing with an unsavory actor. And then some landlords will have you sign, when you sign the lease, that you're going to be leaving when you leave. Pre-signed notices to terminate. If a landlord asks you to do that, that is a warning sign. Now, I'm not going to read all these ones to you, but you all have a packet, and you should read these things carefully. These are called unenforceable clauses. These are things that are inside of leases that are illegal. They can't be enforced. Now, that doesn't mean that your lease is null and void. These are just things that if your landlord tries to go to a judge and enforce them against you, the judge, and I will argue if I represent you, will say, nah, you can't enforce these things. There are 2 choices for unenforceable clauses. The first choice is you see it on the lease and you tell the landlord before you sign, you need to draw a line through this. I know better than that. I know that you can't tell me when I have to leave. I know that you can't have me waive my opportunity to purchase rights. I know that when you go into bankruptcy, that's your business. That doesn't have anything to do with me. These are things that you can ask the landlord to cross that out. But there is a risk with that because it's hard to get rental housing in D.C. So your landlord might just say, thank you, I'll go to the next applicant. And, that's a business decision on part of the landlord. So your second choice is to be aware of these things. And then if your landlord tries to do it to you, call us or stand up for yourself. And in that circumstance, you can say, no, landlord, if my pipes bust, I didn't sign away your responsibility to fix that. And even if I did sign that in this lease, that's not going to fly in court. And you'll be amazed how many times landlords will cower when they know that they're dealing with somebody who's been well advised. And the final thing I'm going to talk about is moving in. All right? Again, as you see, we're walking you through the process, how you find the apartment, where you sign the lease. Now we're finally into moving in, and this is why we're moving fast, because we just moved into the place, and we got a lot of room to cover after that. Moving in. Most important thing about moving in is this, protecting your security deposit. You do not want to be held responsible when you move out for damage you didn't cause while you were living there. All right? That's the bottom line with moving in. When you move into your unit, you need to inspect the place with your landlord in a piece of paper, perhaps some cameras, and you need to document the condition of the place that you found it so that if there's something that you didn't do beyond normal wear and tear, the landlord you can bring that paper up and say, nah, we already documented that this hole wasn't in the wall. So we have at our office available sort of a form that you can use, like a draft of it, and you can contact and get that from us. And we encourage you that you use technology to document the condition of the unit. And then finally, Red Flag Man comes to tell you, again, that you have to take responsibility to never be responsible for someone's before you, the damages that they cause. All right, now, if the place is just completely uninhabitable, you come to move into your new unit and the ceilings have caved in and the place is flooded and it's just you can't live there. You don't have to accept that lease anymore. That lease is voidable in D.C. when it's totally uninhabitable. And you should consult us. It happens a lot. People will be surprised that the landlord would attempt to turn over to them an apartment in that poor of condition. Now, there are other things that happen when it's not quite uninhabitable, but it's not quite right. You move into a place, and obviously this place needs to be painted, or obviously there needs to be some repairs made. Well, when you're moving in, is the best time to stand up to your landlord and say, I signed a product. A product is rental housing. This is a business relationship. I signed away my responsibility to pay you for a product, and now your product is shoddy. You need to do some repairs here before I move in. But if I move in under these conditions, I'm documenting everything because you're not going to hold me responsible when I move out for the things you didn't fix before I moved in. And then the last thing that we will tell you about is sort of what I talked about with the group housings, again, rolling security deposits. Again, never pay a previous tenant the security deposit. The security deposit relationship is just between you and your landlord. And now that we've hit security deposits, we're ready for the next person.
Thank you, Aaron. I hope you all were taking notes. There will be a test at the end of this presentation. And I expect 90% or better. Next, you're going to hear from Mr. William Zachariah Mundy. I don't believe what it says on this little name tag. William Zachariah Mundy. Why do we call him Zachariah? Because his mother did.
Good afternoon, everyone. I hope everyone is still awake. I know that my lunch is starting to kick in. I'm starting to get a little tired, but I'll try to keep things moving so that we can keep it interesting. But security deposits, as I'm sure you know, are extremely important because everybody. Is there anyone here who doesn't like getting their money back when they move out? I didn't think so. So it's extremely important to, as Aaron said, when you're moving in, to document things so that you can help protect yourself when it comes to your security deposit. Now, in D.C., security deposits are perfectly legal, and they're used to help enforce your obligations as a tenant. So they seem like in fact, they're just a way for the landlord to protect themselves. But does anyone here know what the maximum allowable security deposit is? 1 month's rent, exactly. So we don't have a red flag man on this chart, but if your landlord asks for a security deposit that's higher than 1 month's rent, that's certainly a red flag, and that's illegal. And if that happens, then that's probably not someone you want to rent from, because if they're going to try to take advantage of you right when you move in, they're going to try to take advantage of you when you move out. Now, you can see on this slide that it tells you that there are certain disclosures that come along with security deposits. The landlord is supposed to disclose to you how he or she is holding the security deposit, what bank they put it in, and that it's an interest-bearing account. Now, you're only actually entitled to the interest of when you get a security deposit returned if you live there for more than 12 months. So if you sign a short-term lease for 6 or 9 months, you're not entitled to interest, even though you are initially entitled to these types of disclosures. Now, security deposits, when you move out, and there's going to be more information about how to protect yourself when moving out later, but when you move out, for the landlord to deduct something from you, from your security deposit, he's supposed to make an inspection within 3 days prior or 3 days after you move out of your rental unit. And once he makes that inspection, he must notify you whether or not he's going to deduct anything from your security deposit. Now, does anyone know what cannot be deducted from a security deposit? What type of damage? There's a legal phrase that you probably hear. Yes, ma'am? What was it? Exactly. The phrase is normal wear and tear, and that's something that cannot be deducted from your security deposit when it's returned to you. And you're going to hear more about that again from my colleague when he talks about protecting yourself during move-out. But you have a right to be notified of whether any deductions are going to be taken out of your security deposit within 45 days of the date you move out of the apartment or turn your keys over. And within that time period, the landlord has to either, 1, return your security deposit, or 2, notify you that he's going to take deductions. If they do notify you that deductions are going to take place, they then have an additional 30 days to return the money to you, and also return to you an itemized receipt of all the repairs that were made and for damages that they're alleging you caused. Now, does anyone know what they would do if their landlord made deductions that they don't think were reasonable?
Come see you.
Well, come see us is a great, that's actually the perfect answer. And when you come see us, what are we going to help you with? We're going to help you we're going to talk to you about the different possibilities you have. And there's really 2 possibilities. The first is to file a tenant petition. And tenant petitions are an administrative petition geared only towards tenant issues. You file it with the rent administrator, who many of you may have seen here today, and he works for DHCD, and then you get heard in front of the Office of Administrative Hearings. Now, that process can be quite lengthy, and if you have questions about that process, come ask us. And as Dennis mentioned, in the future, there will be a slideshow just about the tenant petition process. Your second option is just to sue the landlord in court. Depending on the amount, if it's under $5,000, which most security deposits are, you can sue in small claims court. If it's over $5,000, you can sue. You'd be forced to sue in the regular civil court, and that's much what you would expect in suit. It's just like a lawsuit. You sue, you ask for damages, you say, he unreasonably withheld my security deposit, you go before a judge, it gets heard. We can help you with that. We may not directly represent you, but we can certainly provide you advice on what to expect, how to best protect yourself along the way. Now, the next topic I'm going to talk about is rent receipts. In the district, you are entitled to a rental receipt for your payments. Who here, does anybody in this room pay cash for their rent or occasionally pay cash when they pay their rent? Okay, we have a couple of you who do. Now, especially when you're paying in cash, it is extremely important to make sure you get a rent receipt. Every week, probably more often, almost every day, we have people come to us and say, I paid my landlord, he filed in eviction court, I don't have receipts because I paid him in cash. Whether or not they are being honest with us, I'll leave that for you to judge. But certainly some of them are being honest. And the problem that comes with this is if you can't prove you paid and your landlord is dishonest, there's not much we can do to help you. You can get up and you can argue in front of the judge, but if the judge doesn't believe you, then you might lose your housing. And that is certainly something that we don't want to happen and you don't want to happen. So always ask for a receipt. Now, you're entitled to a receipt under almost every circumstance. The only time you're not is if you paid by personal check and you paid your rent in full. And in that, you would certainly, hopefully, you would get a return check from your bank after it is properly paid. You get the voided check, or sometimes nowadays they just email it to you. But make sure you always keep those records of your payment. Now, what if you paid a partial payment? Now, you paid a personal check or a money order, and your landlord didn't tell you that you had a late fee. So maybe you paid your $1,000, but it should have been $1,050. Now, the landlord is obligated under that circumstance to give you a rent receipt, even if you don't ask for one. As you can see here, there are 4 things that the receipt must state. And most important is if a balance remains. So if there's $50 that you were short and you don't realize you're short, and your landlord doesn't give you a receipt, that's an issue. And you should certainly come to us and we can help try to rectify that problem and help moving forward and protect you from having to pay that ongoing balance. Now, this slide is the only slide we have on rent control in this, and this could certainly be 5 different presentations. Rent control is one of the most complex issues within the district, especially for renters. Now, rent control limits the amount of rent increases you can get. It limits them both in frequency as well in amount. Now, if your unit is under rent control, you can only get a rent increase every 12 months, not more than that. And there are automatic rent increases that come in with that. Now, does anyone know what the automatic or annual rent increase is for the district if you're under rent control? 10%. It's not 10%. So this year, it is 4.2%, and what 4.2% represents is it's called the CPIW plus 2%. Now, the CPIW is the Consumer Price Index for Washington, for the Washington area. It includes parts of Maryland and Virginia as well. And for this year, it's set at 2.2%, so then you get an additional 2%. So if you are on a rent-controlled unit, your annual rent increase this year should only be 4.2%. If you got an increase for more than that and your landlord didn't file a petition and you are subject to rent control, then you should come talk to us and we can help file a tenant petition or file a case for you or help you file a case so that you can then get a rollback on your rent. Now, how do you know if you're under rent control? You saw earlier when my colleague Ramona Quillette talked to you about verifying the unit. Now, on there's information on how to contact DHCD to see if your landlord is registered. And with the registration for rent control, there's also an exemption portion of that form. Now, your landlord, as you can see on the slide, there are 7 different ways a landlord can be exempt. One of the most common ones is a small landlord exemption. If your landlord owns 4 or fewer units in the district, they may be exempt from rent control. So if you don't know your status under rent control, if you don't know if your lease or your unit is subject to rent control, contact DHCD and ask to see the claim of exemption form, registration form for your unit. You can find out whether you're subject to rent control and whether your landlord has been giving you proper rent increases. And the general guide for whether you're subject to rent control is up here, and you can certainly read it. All buildings built 1975 or prior, owned by business entities or persons who own 4 or fewer units, as well as those who are not subject to a federal or DC subsidy. So those are some of the common exemptions that generally rent control applies to all the other units other than those types of units. Now, if you have an issue with a rent increase, you think you got one too big, as I said, we can help you file a tenant petition to get a rollback for that and help protect your rights going forward. Now, my second extremely broad slide, that could be another 10 presentations, is the housing code. Has anyone ever had a housing code violation in here? Exactly. A lot of people have housing code violations in the district. And housing code enforcement comes under DCRA, the Department of Consumer and Regulatory Affairs. And you can see the inspection hotline is up there. You can call and ask for an inspection whether or not to determine if you have a housing code violation. And also on the DCRA website, if you go to dcra.dc.gov and search housing code, they have a general guide to the housing code because the housing code is pretty complex. There's multiple chapters within Title 14 that explain all of the housing code, but on their website, they have a web page that gives you a guide of what sorts of things may be housing code violations. Now, if you have a housing code violation, there are 3 remedies as opposed to 2 with some of the issues we previously talked about. Again, you can file a tenant petition. You can claim a reduction in services or facilities and ask for money back from rent you've paid. Say, my rent was $1,000, but because the window was broken, because the door didn't lock properly, because my carpets were ripped, because there's a leak in the wall, I think I should receive X% of my money back. And you can certainly ask for that when you fill out your tenant petition. You would just check that box that says either temporary or permanent reduction.
Folks, there's an interruption to your regularly scheduled program here. Is there an Ann Dicker here in the room? Never. Then in that case, never mind. I'll return you to your regularly scheduled program.
All right, back from the commercial break. So, as I said, the tenant petition, you can ask for money back. And small claims or regular civil court, same exact thing. You can ask for a reduction based on the services that you received because you were promised more than you got. Now, one thing that's unique to housing code violations is called housing conditions calendar. You can't get money from housing conditions calendar. It's a streamlined court within the superior court that all they do is get things fixed. You're going to file a complaint. There's a form that's very simple. You can come to us to get it. You can go to Superior Court to get it. You just check boxes. You check windows broken. You check whatever your issue is. You file it. You go before a judge. Often it's Judge Wright or Judge Bartnoff is the other one. So when you go, you tell them what your issues are. They have an inspector there, a DCRA inspector, Miss Seidensticker. She's one of the best inspectors at DCRA, which is why sometimes we advocate you go through housing conditions calendar because she's so thorough in what she does. Now, when you go to housing conditions calendar, as I mentioned, you can't get money back, but you can get things fixed quicker. If you call the inspection hotline, an inspector will come out, they'll issue a notice of violation. It's the same thing that will happen when you go to housing conditions calendar. But in housing conditions calendar, Judges Wright and Bartnoff have a little more enforcement power than the regular DCRA inspector does. Question?
I do have a question about the entry door to my building. It's repeatedly being broken by the neighbors.
And for a specific issue like that, I would recommend coming to our office or calling our office. We have walk-in hours between 9 and 4 Monday through Friday.
Would I call this?
And you can also call DCRA. So if you want to go to Housing Conditions Court and want help filling that out, you can come to us. You can call DCRA directly and get an inspection.
Also, yes, a commercial interruption number 2. And for very specific questions of that nature, we do have attorneys on site downstairs. Believe it or not, they are not fully booked for the afternoon. So while I would never encourage anyone not to stick around for the following presentation, I would never do that. If you are so inclined, there are attorneys downstairs that would be available to you this afternoon.
And yeah, so there's another great resource for you. You can go down and get on-site advice right now for your door problem. The next thing is quiet enjoyment. And quiet enjoyment is a legal term that represents living peacefully in your unit. Even though it has the word quiet in it, it's not limited to just noise. It could be a number of different things. It could be your landlord entering your apartment without giving you notice, entering when you're not there without telling you ahead of time. It could be something like smoke from the hallway. It could be construction limiting your access to the building. And it can also just be construction noise or other issues with noise. So it certainly can cover noise, but it's not limited to that. And you have a right in D.C. under every lease, whether or not it specifically states or not, to live peacefully in your unit. As I mentioned, that's what quiet enjoyment means. So if you have an issue with that, you can certainly come to us. If it's something that deals with, say, if it's construction noise, you can always file with DCRA and have them come out and take a noise reading to see if it's too high. I will let you know that there are certain minimums. So they can make certain levels of noise, and they are usually limited to business hours when construction is allowed. So just know that some noise is allowed, but not all noise is. So you can certainly ask DCRA to take a noise reading and determine whether it's acceptable. Because this is more of a complex issue, quiet enjoyment, if you have any questions, certainly come see us, ask questions about it. Question? Can you just hold your question at the end? We just have one more speaker, and then we'll go through all the questions you guys have. So my final slide is about discrimination. Now, obviously, everyone knows that you can't be discriminated against if you're in a protected class. Now, that's, again, a legal term. Now, what does protected class mean? Protected class is what is listed up here. In rental housing, in the District of Columbia, there are 18 different protected classes. Some of them are normal ones, what you would expect. Race, gender, religion, country of origin. These are things that I'm sure all of you have heard about in high school. You learned about American history. You know all about discrimination when it occurs. There are also some other ones that you may not think of. Familiar status is a common one. If you have a child, your landlord can't really tell you, well, you now have a child, this is an adults-only building. That's not something that really is acceptable. And I received a phone call about that last week. So it certainly does happen, and it seems crazy, and it is crazy. You can't let that happen. Another one, matriculation. If there's any students in here, you can't be discriminated based on whether or not you are a student. It is more, we get a lot of, first-time renters, college students. There's tons of colleges and universities within the district. So that's not something that they can discriminate based on. DC, one of our sister agencies, is the Office of Human Rights. All they do is investigate discrimination claims. So if there's a claim based on discrimination that you have, what we're probably going to do when you come to us is refer you to the Office of Human Rights. And the Office of Human Rights, their contact information is there. They will investigate your claim. They will investigate the veracity of your claim to see if it's true. And then if it is true, you have a much stronger case when it comes to court if you want to sue your landlord for claims of discrimination. If you get your claim certified by OHR, you're going to have a very strong case going to court. And there are certain legal issues why that's beneficial, so it can help you. So contacting OHR is always the first step if you think you have a claim of discrimination. And back again, Mr. Red Flag Man. So what you can see to be aware of discrimination is the triggering events for discrimination. If you think that when you're applying for a unit that a landlord is refusing to rent to you based on your race or gender or religion or any of these 18 or a disability, any of these 18 protected classes, then you probably have a claim. And if you think that he's giving you unfavorable terms or making you pay more because of one of these things, then again, that's discrimination. If he is refusing to make a reasonable accommodation to someone because but this reason stems from a protected class, the last one up there usually applies to disabilities. So they have an obligation to make a reasonable accommodation. Because disabilities can be a wide range, it's hard to tell you what a reasonable accommodation would be. But it's certainly something you can ask us or OHR about and determine what is reasonable and what's not. And if you have any questions about my portion, then please feel free to write them on the index cards, give them to Hisham, we'll answer them at the end, and with that, I'm going to pass it off to my colleagues.
Thank you very much, Zachariah. Good. I'm glad this slide is still up here. I saw something a couple days ago that really surprised me. I saw a gentleman recite all 18 of those protected classes in order, by memory. Now, he was a former professor of mine over at Georgetown. He's now chief administrative law judge in the employment area of D.C. Doesn't change the fact that it was very impressive. Again, did I say there's going to be a test at the end of this session? Now, I won't tell you what the test is going to be over, but notice that there are 18 categories here. Come to your own conclusions. Okay, now, our final presenter today is going to be our senior litigating attorney. Because he's our senior litigating attorney, we gave him a few more slides. I hope you doesn't mind, especially because he doesn't have a lot of choice in the matter anyway. This is Mr. Amir Sadeghi.
Thank you, Dennis. And thank you, everybody, for being here. Before I get started with the substantive portion of my presentation, I wanted to remind everybody of just how important it is that you're here right now and that when you leave, you continue being active, not just in coming to see us, because that's what we're here for, but in helping spread the word. You know, wearing these T-shirts and giving out the things that we're giving you, because the more of you are aware of how to protect your rights, the more we can do for you and the more you can do for yourselves. Now, because I'm the most exciting attorney at the OTA, got the most exciting portions to talk about. And of course, eviction is one of those things. One of the most important things that you need to know about eviction is that there are 10 very specific reasons that can be used in order to perform an eviction. In other words, a landlord, just like Aaron said earlier, cannot simply decide that I don't want you as a tenant anymore, so you have to leave. That's in the district. That is the protection that you have. Other states, other territories do not have such a protection. So we're fortunate to have that. So it's important for us to exercise our rights and to know what are the reasons why a landlord can and cannot evict us. Now, I'm not going to go through those because you have those in the presentation before you. But it's important that any time you feel that your landlord is attempting to evict you, either directly or indirectly, you come see us. Come see us if you think your rights are being violated in any way, shape, or form. Come see us if your landlord is harassing us. And look, you know what? If you're just bored and you want someone to talk to, call Ramona. Now, evictions in the district cannot be effectuated without the judicial process. And I'm going to go through that judicial process with you. But again, like Aaron mentioned before, just because your lease is up doesn't mean your landlord can say you've got to leave. Now let's talk about this judicial process. I need one volunteer, just one volunteer. You don't have to do anything. You can sit there, look pretty. I just need your name. Somebody please raise your hand. Yes, young lady in the back. What's your name? Wing. Wing? Yes. Like chicken wing? Yes. Okay, great. Wing. All right. Wing, thank you for volunteering. You are going to be our tenant du jour, all right? You're going to be the tenant of the day, and we're going to go through the eviction process, okay? Okay. We also need a landlord and a property manager. And I'm not going to... You want to be the landlord? You want to be the landlady. All right. What is your name, ma'am? T-E-T? Lois? Got to pick one. Lois? Ted. All right. Ted is the landlady. All right. So we got Wing the tenant, Ted the landlady, and we also need a property manager and an attorney. What's your name? Brenda. Brenda is our property manager. Okay. One more. Attorney. Yes, ma'am. Rice. Okay, R-I-C-E. Okay, so we got Wing, Tet, Brenda, and Rice. Are we good so far? Okay. 5th of the month comes up. Wing hasn't paid her rent. The lease says she's late. Tet says to Brenda, she's late, tack on the late fees, right? Brenda says, okay. 10th of the month comes, she still hasn't paid. So generally a landlord, this situation, Tet, would say to Brenda, all right, Brenda, you've got to file a suit. Wing is not paying her rent. She's gone off to AC and gambled off Atlantic City and gambled off her rent money. So I need to sue her. Okay. Brenda says, all right. Brenda calls Rice and faxes her or emails her the list of all of the tenants who have not paid the rent on time. Rice then files a complaint against all of those tenants. So by the middle to the end of the month, all of the tenants who have not paid their rent are going to get a complaint filed against them. That is generally the process that happens. Now, this is just for non-payment of rent process. It's a little bit different for the other way of evicting somebody, which doesn't have to do with non-payment of rent. But let's talk about the more common way. All right. So, Wing has to be served. She has to be served the summons, and the way they do it is they have to come to your house and serve you personally or somebody at your house. And if they try that a couple of times at different times of the day and you're not there, they can just post it on your door. So once they do that, now you have a summons, you've got to go to court. This is when the fun starts, right? So you go to court, and if you have already paid by then, if you've already come current, then they should dismiss your case, right? So Rice will go to court and say, Judge, this one's dismissed. She's paid. But Wing hasn't paid the rent. So she goes to court, and the judge says, all right, Rice, all right, Wing, you guys go out and see if you can resolve it. So they go outside, and Rice says to Wing, here is what I would like for you to sign, a consent judgment precipice, or CJP. If any of you have been in landlord-tenant court, you've seen it. What it tells you essentially is, here are the lines, here are the dates that you can pay your back rent in addition to your rent that is due, and then you're going to be current, right? And if Wing has the ability to make those payments, she's going to sign that consent judgment precipice, and she's going to say, all right, that's fine, I'll sign it. It's sort of like a payment plan. Here's the important thing you need to know about that CJP, or consent judgment precipice. It is a judgment against you. If you do not make those payments, then your landlord doesn't have to go back to court to start a new proceeding. It's essentially like saying to the landlord, all right, I agree to give you a judgment. If I pay these payments on time, then case is dismissed. But if I miss even just one payment, if I'm late just by 1 day, or if I'm short by $1, you, the landlord, have a judgment against me. Now, the other option that Wing has, let's say she has a defense. Let's say she didn't go to Atlantic City, right? Or she did, but she won. But the point is, she has the money, but she has a reason for not paying, right? Now, there are some people, and this is very important, there's some people who say, well, you haven't fixed something. My refrigerator's broken down. You haven't fixed it, so I'm not going to pay, right? We never, ever recommend that. I want to be very clear about that, because that's a very simple way of getting yourself dragged into court. We do not recommend a rent strike. If something like that happens, come talk to us. We'll show you how to go to to Housing Conditions Court to protect your rights and force the landlord to make the repairs. But let's say she has a defense like that. That's a legitimate defense. Then she can go to court. So it'll be her and maybe her attorney up against Rice, and maybe Brenda has to go to court and testify, and maybe Ted has to go to court and testify, but then there's going to be a trial. So that's the other alternative. But let's say that she signed the consent judgment precipice, or let's say the landlord got a judgment against her, Or let's say she doesn't show up. Well, if she doesn't show up, automatically the landlord is going to have a judgment against her. It's going to be a default judgment. What happens then is the landlord has to file a request, a writ for execution of the judgment, right? And this writ, W-R-I-T, what it does, it allows the marshal to essentially aid the landlord in the evictions process. Because a landlord in the District of Columbia is not allowed to engage in self-help. In other words, a landlord can't just throw your stuff out, change the locks, and say, you know what, you got to go, I want my place back. Cannot ever do that. So, the landlord gets the judgment, they get a writ, then once the writ is live, that means that at any day, that eviction can be scheduled. So what is your right at that point? Does anybody know how long you have to pay your rent before, in order to prevent an eviction from happening? What is the cutoff date? Yes. That's right. That's right. When you see them right at your door. It really is the case. So let's say they've scheduled your eviction for, let's say they've scheduled your eviction for this morning, right? So Rice comes to your door with the marshal, and Ted and Brenda, they're there too, and they've hired 3 wonderful friends of theirs to come help move your stuff out, right? So Aaron, Ramona, and Zach, they're like, all right, we're going to help. They need a crew to sort of put the stuff out in the street. So let's say they all show up at your door. You can say, not so fast, boys and girls. I've got the money. I am redeeming my tenancy. You cannot evict me. In the district, now we don't need to worry about other states. Don't even go talk about Virginia. But in the district, you have up until the day of the eviction. Now, do you ever want to cut it that close? No. You absolutely do not. Because if you're short, again, if you're short just $1, they don't have to take the money, right? So then the next question is, how much do you have to pay in order to prevent the eviction from happening, right? There is an amount, the full amount, but what's the full amount, right? It's called the term that lawyers a lot of times use is the trans-lux amount. And essentially, it's all of the rent that has not been paid, in addition to all of the court costs and fees that have not been paid, but not just the amount that was included in the original judgment, right? So, Wing, let's say that Rice took you to court in August, and it's now September. The marshals are knocking on your door. They want you out. You have to pay the August rent, court costs, late fees, plus you also have to pay the September rent to be current. That's important for everybody to know that. Yes, well, it's everything including that month that's due. Yes. Sir, I would love to answer all of your questions, and they're very important to us. Please write them down, and as soon as we're finished, we're going to take all of your questions. And I apologize for not doing that right now, but we've got to get through this. Now, relocation assistance is another right that you have as a tenant, and there are certain situations where the landlord will file an action to either do an alteration or some sort of renovation of the place where you live. And in that situation, they're going to ask for you to temporarily leave. Now, sometimes it's not temporary. For example, if they want to demolish the unit where you live. In those situations, they have to pay for you to relocate. So they've got to pay your moving expenses. And if you're unsure about whether or not they can do that, or whether or not they have to pay for that, please contact us, and we'll tell you. Retaliation. You as tenants have rights. We've already covered that. You have the right to exercise those rights without the landlord trying to retaliate against you. All right? So what are the rights that you have? Well, they're listed right here. I'm not going to go through them, but let's say you decide, you know what, what's your name? Sarah? Okay, let's decide Sarah, let's say Sarah decides she wants to form a tenant association. She wants to unite the tenants. All of a sudden, the landlord finds out, and Ted over here, she's like, well, I don't like that, and I'm going to raise your rent. Or you don't have access to your parking space anymore. That's retaliation. And if it happens within 6 months of a tenant exercising his or her protected rights, it is automatically presumed to be a retaliatory action, and you have a right to be protected against it. Now, it's not a standalone cause of action. In other words, you can't just sue for retaliation. But if there is something else that has happened, like one of your rights have been taken away, and you have sued the landlord for that right being taken away, retaliation allows you to increase the damages that you receive. All right, we've already covered this. Ramona's friend, we're not going to get into it anymore. But the right to organize. I just addressed it a minute ago. Look, it's very simple. You have a right, and a lot of times it's very important for you to exercise that right, to unite, to organize. You have the right to post for other tenants to know, to contact other tenants, to hold meetings. These rights are all very important, and nobody can take that away from you. If anybody tries, come see us. Conversion. There are times when a landlord will attempt to convert a rental accommodation, an apartment building, to condominiums. Now, they can do that. However, there are certain limitations. For example, they have to have the permission of the majority of the eligible tenants. Without that permission, they cannot do it. They also have to file it with the District of Columbia. And even if they do convert to condominiums, if you are a low-income tenant, as defined by the district law, and you are 62 years or older, or you have a disability, then you are protected in that you don't have to leave. In other words, you can stay as a tenant, even though all the other units have been converted to condominiums. You can stay in your unit as a tenant. TOPA. Now, this is another slide, like many before, that could cover the entire, could have a seminar just on its own. The Tenant Opportunity to Purchase Act. In brief, all TOPA says is, if Tet decides that she wants to sell her unit, Wing, the tenant, has the right to say, okay, I get first dibs. I get to buy it before anybody else does. So Tet says, I want to sell it for $300,000. Wing can say, no, that's too much for me. Or she can say, yes, I want to buy it at that price. And then she has to sell it to Wing if Wing offers her the price that she's asking for. Now, you can also do other things in TOPA situations, such as transfer your rights to someone else. And there are a lot of nuances to TOPA. For example, if you're living in a building with 5 or more units, then it's only the tenant association, not an individual tenant, that can exercise the TOPA rights. But any time you have received an offer of sale, or you believe that your unit or your building is in the process of being sold, transferred, or demolished, or your landlord wants to stop using it as a rental accommodation, please come talk to us, and we'll help you protect your rights. Finally, there's going to be 2 more slides, and that's about the moving out process. The moving out process is sort of the last piece of puzzle here in terms of protecting your rights. Now, we told you, look, when you move in, make sure you take photographs. Make sure you account for everything that you paid for the landlord and for the conditions of the premises. Well, when you move out, you have to send a notice to your landlord giving them a heads up that you're moving out, just like your landlord would have to send you a notice if they want you out for any reason. Right? And the notice depends on, the length of notice depends on your lease agreement. Sometimes your lease agreement will say you have to send them a 1-month notice, sometimes 2 months notice. So make sure you know what that is and the length of it. And one thing to be aware of here is if you're on a month-to-month tenancy, let's say you want to move out by the end of September or by the end of November, you have to give notice before the beginning of November. So let's say you give notice October 15th. That's not a 30-day notice to November 15th. It expires at the end of that next month, so at the end of November. Make sure you arrange a walkthrough, and make sure you take pictures of everything, and make sure you leave your landlord your forwarding address, any other contact information, so they can contact you, send you your mail, and any other information. And finally, make sure that you leave your unit in good condition. Anything that's beyond normal wear and tear, your landlord can charge you for. So for example, you've got this carpet here. Just from walking up and down the carpet every day, it's going to get stained, it's going to get a little dirty, right? Your landlord cannot charge you for that. But if you spill red wine and there's a big red wine stain, your landlord can say, well, that's beyond normal wear and tear, and I can charge you for it. Or if you break a window, or if you break a door, or something like that. That concludes my portion of the presentation, and I thank you for your attention. I thank you for being here, and have a great rest of the day.
Thank you, Amir. Okay, folks, several times today you have heard it said, come visit OTA. Where are you going to do that? I'm going to make it really easy. Look at the back of your program. It has our address, the Reeves Center, 2014th Street, otherwise known as the intersection of 14th and U Northwest, Suite 300 North. You can call us. The number is on the back cover of your program. Now, while I am talking, Mr. Mokhtari is going to be walking around collecting note cards with questions. We'll get to as many as we can before someone comes and forces me to hand over the microphone to the next session. But I also want to say that today we are featuring, I feel like I'm a waiter at a restaurant, we are featuring our afternoon specials of OTA Online. How do you go to and take advantage of that? Well, first of all, you would go to the OTA website. Where is it? It's right there. Your test today is going to be to write that down. Once you have done that, what are you going to find? In addition to all kinds of wonderful resources to help you, you may find one of our most popular features, Ask the Director. That is where you type in a question into your computer, you hit send. And I can tell you that that question is going to be answered as quickly as Mr. Horace Lassiter can answer it. And our director will see it before it goes out, as will I. But yes, your question will be answered. If you do not want to wait, and if it is the final Tuesday of every month, between the hours of 1 and 2, have I narrowed it down enough? Yes, there is a live question and answer chat online. I'll leave that up there. Oh, this wonderful person who's shown answering all the questions, I will tell you now, I have no idea who that is. Yes, ma'am. Can I define what is a tenant? I'm going to tell you what I tell everyone when it comes to a point of law. As a general rule, I can, because I go back to the law and I read it word for word, and I like to go back and look at it rather than say it from scratch, because I might make a mistake and I don't want to tell you something that's wrong. I have not memorized it, and I would want to look at it. Have any of you memorized the definition in the law? Thank you. No, they do not have it memorized. While we're collecting, I suggest you go, first of all, to DC statutes, Title 42, Section 3501, parentheses or dot 3. Now, I'm going to very quickly, I'm sorry, 3501.3. Now, I have a few in advance. I hope you wrote your name on your questions because I see people trying to get in here and take this mic away from me. But I'm going to go through 3 very important ones that have already been handed to me. Why doesn't the Department of Consumer Regulatory Affairs inspect DC Housing Authority properties? Truth is, they do. It's not easy. The best way to make it happen, and I'm glad you're listening today, you go to the housing conditions calendar that was talked about earlier, you file a claim, you get in front of Judge Wright, and Judge Wright will tell the housing inspector next to him to go out and inspect the property. That is a DCRA inspector. When the judge tells them to go, they go. Very next one. Does this agency help DC Housing Authority residents that are not housing choice voucher holders? Yes. And the last one, I told you someone's going to come in here and rip this microphone away from me. If the landlord sells the building, does the owner have to relocate you because you have lived there over 10 years? The answer is no. However, just because the property is sold does not mean you have to leave. If you go back to your notes, those 10 reasons for eviction, you will find that selling the property is not one of them. With that, I hope you hang around because there's another great presentation starting right away. If you handed in questions and you put contact information on them, you will be contacted this week. And finally, can you hit the next slide, please, somebody? Oh. Thank you very, very much. You've been a great audience.